Well, hello everyone, and thank you for joining me today. We're going to be discussing estate planning that protects you during your lifetime. Hi, my name is Lynn St. Louis, and I'm an estate planning and elder law attorney at ELG Estate Planning. We serve clients in the state of Washington and in Idaho. So if you are watching from a different state, keep in mind that what we're talking about may or may not apply to you. So let's go ahead and get started. So when it comes to estate planning, most people think about that as what happens when I die? Where does my estate go? Where does my stuff go when I die? And of course, that is something that happens with estate planning is maybe you have a will and it says where your assets go, or maybe you have a revocable living trust or other kind of trust, and it says where do your assets go. But what's really important, something that I want to talk about with you today, is how does estate planning protect you during your lifetime? Because in my opinion, as an estate planning and elder law attorney, it's more important to protect you while you're alive than making sure where your assets go when you're gone. Both are important, but more important is making sure that you and your decision-making, your autonomy, your voice, your wishes are heard and that you are protected while you are alive. So how does estate planning do that? If you have a will, that only covers what happens when you're gone. In your estate plan, you should have what I call living documents. Living documents are durable powers of attorney for finances, for healthcare, and a medical directive that's called, depending on where you live, it's called an advance directive or a healthcare directive. It's commonly known as a living will. Those are the basic living documents that should be a part of your estate plan. And we will talk about those today. We're also going to be talking about how do you protect your assets while you're alive, especially against long-term care costs. How do you protect your assets while you're alive from threats, creditors' claims, and such? So we'll talk a bit about trusts, revocable trust, irrevocable trusts, LLCs, those are limited liability companies. Those are the primary ways that you can protect your assets while you're alive. And again, keep in mind that I'm going to be talking about Washington state law. If you live in a different state, your laws are going to govern what kind of protections do you get from these various legal entities. So let's get started with the basics. Durable powers of attorney, the most important legal document you can have. Everyone who is over the age of 18 should have a durable power of attorney. Why is that? Let's talk about what a durable power of attorney is. It is the way that you put in writing who will be your decision maker in case you can't be your decision maker. And none of us like to think about that we won't be in charge of our life, in charge of what we do, of our assets. We all want to be in charge until the day we die. But we all know that things do happen to people that result in them not being able to make decisions. Let's say, for example, you have a special needs child, and depending on the level of their impairment, they may be, as an adult, under a guardianship. A guardianship is where the court makes sure that that person and their assets are protected. And sometimes a guardianship or conservatorship, I'll use those terms interchangeably, sometimes that they're absolutely necessary because the person that is being protected never had the legal capacity or ability to sign any estate planning documents because they don't have the ability to understand them. They are incapacitated. Some people are born incapacitated and they'll never have capacity. Therefore, they will be under a guardianship when they become an adult. And that's absolutely necessary if that's that person's situation. So who is in charge of somebody who is under a guardianship? It will be their guardian. It sometimes is a family member, sometimes it is a professional, a certified professional guardian. It depends on the situation, the family dynamics, and who is available. But under a guardianship, there is a court proceeding, and the court is making sure that everything is being done correctly, that the person's assets are being managed correctly, that they have a personal care plan. And the court has to give its stamp of approval when somebody is subject to a guardianship. Well, you can tell, I would think, that what that means is that there is a lot of work that goes into a guardianship. Personal care plan is filed, financial plan is filed, there are hearings, the court gives its approval, there are costs, especially if there's a certified professional guardian, they get paid by the hour typically for their time. And of course, if there's an attorney involved, you've got legal fees. So a guardianship or conservatorship will be a proceeding that costs money, ongoing every year, year after year, year after year, year after year. And that is a necessary proceeding for some people. However, if you are somebody that has legal capacity, that means that you understand what is being said, that you can make decisions for yourself, that you are a capable person, and this is a broad standard here, that you can sign your own legal documents. You can sign legal documents that you prepare yourself or that you get online, or that you pay, online $500 for, or maybe better yet, that you went to an attorney who can give you legal advice. So if you are a person who is capable of signing legal documents, I hope that if you are over the age of 18, you have done so. And again, and I get back to what are the most important legal documents you can sign: your durable powers of attorney. Your durable powers of attorney will grant authority to somebody else to step in and be your voice if you cannot be your own voice, if you cannot make your own decisions. And if you have such a document, then there is somebody who will be taking care of your affairs, your financial affairs and your healthcare affairs. If you don't have these documents in place, and should you lose capacity, then you will be subject to a court-ordered guardianship, conservatorship, as I earlier explained, that proceeding which is necessary for people who don't have capacity, don't have legal capacity. So one of the key benefits of having durable powers of attorney is that you should never be subject to a court-ordered guardianship if you lose capacity. We all know there's many ways to lose capacity. For some, it could be Alzheimer's, or it could be some form of dementia. It could be from a stroke that you lose capacity, or it could be from an event such as a car accident for a younger person. I know not a whole lot of younger people think, oh, I need estate planning, I need durable powers of attorney. For one thing, younger people believe themselves to be invincible, as is what we expect with people who perhaps are in their 20s or 30s. But once people start having children and their families grow, then they start thinking about, I need to protect myself. I need to protect my children. What if something happens to me and to my spouse? What's going to happen to my kids? So at some point in time, people do start thinking, I should look into estate planning documents. Make sure that when you look into estate planning documents, you don't go to an attorney that says, oh, all you need is a will. Because if they tell you that, they are wrong, unequivocally wrong. You need the living document. So if somebody says all you need is a will, that's bad advice. So the durable powers of attorney, why are they called durable? The word durable actually is really important Durable means that this legal document that you have signed will continue in effect even after you've lost capacity. That's the reason you have this document. Therefore, it should be durable. And frankly, if you never lose capacity, if you're in charge of your affairs to the day you die, great. It's kind of like having insurance in place. You never needed it, but it was there just in case. So it's a durable power of attorney. It doesn't have to be two separate documents. You don't have to have one for finances and one for healthcare. At ELG Estate Planning, we do prepare them separately. The reason that we do that is that, well, these are very comprehensive and robust documents that we provide here, and I'll get into that in a moment as to the reason why. But maybe for your financial durable power of attorney, you want maybe a family member who is really good with finances and very responsible with finances. And maybe for your healthcare, your personal power of attorney, durable power of attorney, you want somebody who is very good with healthcare, who will make really good decisions for your healthcare. So these might be separate people. So it makes sense to have these documents as separate. And even if you have the same person making both decisions, let's say you're married and you appoint your spouse, and then after that, one child and then another, you still might want those to be separate. We recommend they are, because you're going to give your doctor, your primary doctor, your healthcare power of attorney, and you're going to make sure your bank has your financial power of attorney, so that if that person needs to act under either of these documents, there's not going to be any question as to their validity and that they are enforceable. We do prepare the financial and the healthcare powers of attorney as separate documents. A couple of things, just kind of tips when it comes to your powers of attorney. Take a look at them if you have them. And by the way, congratulations if you do have them. That's great. That's proactive planning. That's empowering your life. Fantastic. If your document is old, if it's older than 10 years old, I can tell you it's going to be difficult for the person acting under your power of attorney to have it accepted. If it's under 5 years or older, less problematic, but it still could be. I mean, sometimes you hear attorneys say, oh, you have to update it every 2 years. I don't agree with that, but I do recognize the validity of the point, which is the older the power of attorney is, the less likely it will be accepted, for example, by a financial institution. Not so much by medical. Doctors will accept it more likely than somebody who's going to your bank and trying to get money out and act, as write checks for you, etc. If, it's an old power of attorney, the bank's going to kind of look at it and go, is this valid? Is this the most recent one? So the newer it is, the better. Typically, that's not always anything an attorney says. It's not always 100% always better if it's newer, not necessarily, especially if the person had it, maybe a family member came in, and there's something called battling powers of attorney. Family member takes somebody to a lawyer, gets it done. The next family member gets something online and has the person sign it because the person's really lack capacity. That's a whole nother problematic area that I'm not going to spend too much time on. But what I want you to know is that at least review your estate planning documents every 5 years. That's a good rule of thumb, every 5 years. If there are problems with your power of attorney being accepted by a financial institution, the attorney who drafted it can prepare what's called an affidavit about the validity of the document. And having that affidavit is going to make it much more likely that the financial institution will accept the power of attorney. So all of these powers of attorney are great to have. You need to have them. We hope you never use it. But if you use it, if it's going to be used, it's because you lack capacity. And if you lack capacity, if you want to stay out of the court, if you don't want your personal affairs, your financial affairs to be part of the state court-run system, you need to have good, durable powers of attorney. So let's talk about what is a good, durable power of attorney. That would be one where you've named first one person, then you've named another person, and then you've named another person. We really like to see 3 successive designations for who will be your agent, your power of attorney under your document. You don't have to do that, but I can tell you if you only name one, what's going to happen to your power of attorney, the effectiveness of it, if that person you've named is not capable. Or if you name joint co-powers of attorney, two people to be making decisions, that also can be problematic. Oftentimes if they're joint and they have to agree, what happens if they don't agree? It ends up in court. Or if you name two people and they're independently authorized to make decisions, what happens if they don't communicate? Well, it becomes a mess. So our recommendation typically, not always, but typically is you name one person and then another and then another. Do you need a power of attorney if you're married? Yeah, you do. Why? Because you are your own person and your spouse is their own person. And just because you're married doesn't give you any legal authority to manage their affairs. And couples get really confused when I make this statement. How could that be? I mean, you both can write checks off of the same account, right? You can, I'm showing my age by saying writing checks, but you both can transact under your bank account, right? Well, yes, if it's a joint account, but what if it's only in your name? You don't have any legal authority to manage your spouse's bank account. You can't sell your house without your spouse also signing off on the sale of the house. Even if both your names are there, you can't do it. You need legal authority to do so. So spouses, you both need durable powers of attorney. And when it comes to, well, how good does this legal document need to be? In my opinion, it is critically important that it be a very good document, not some form and not something that was just given to you by an attorney that says, hey, I can do your will, I can do your powers of attorney. And they also can do a bunch of other things for you because they're a generalist. I really recommend that you see an elder law attorney, and this is why. An elder law attorney understands government benefits. We understand what it takes in a power of attorney to have sufficient authority to do planning that's going to save you money, especially in the face of long-term care costs. As people age, long-term care goes from being a possibility to a probability. Long-term care is very expensive. $5,000 a month, $10,000 a month, $15,000 a month. What that means is the money goes very quickly. An elder law attorney should put into your durable power of attorney for finances the necessary authority that's needed such that if you lose capacity or your spouse loses capacity, that we can, as an elder law attorney, help you protect assets while at the same time qualifying for Medicaid long-term care benefits. Medicare doesn't pay for long-term care. Medicaid does. And we'll talk about, I'll give you some examples of how you can protect assets against Medicaid and long-term care costs. It's important that you have robust powers of attorney, especially when it comes to financial matters. The other living documents, so I've talked about a durable power of attorney for finances, a durable power of attorney for healthcare. Keep in mind that you're also going to want to have what most people refer to as a living will. That's nothing to do with a will. It is what your wishes are should you be at end of life. In Washington, we call it a healthcare directive. Other states call it an advance directive. People commonly call it a living will. They all mean the same thing. What is it? It is a legal document where you have put in writing what your wishes are if you are at end of life. If your doctor or two doctors have put into writing that there's no other medical treatment that's going to make you better. We can prolong the body, the life of the body, but this person is not going to recover. So in other words, we often say it prolongs the dying process. And if that is the situation, you want to make it known. Do you want heroic measures to keep your body going, or do you want to be allowed to die peacefully? That's your decision. There's no right or wrong from an attorney's perspective. What is necessary, though, is that you state it. You state it in writing in your healthcare directive, advanced directive, living will. So those are the documents that are critically important for everyone who is an adult to have in place to make sure that their voice will be heard, their wishes are known, that there will not be court involvement in litigation and fights over that person's life. Make sure you protect yourself, empower your voice, make sure that is heard no matter what happens to you during your lifetime. All right, I'm going to start talking a little bit about now not so much protecting you, but protecting your assets during your lifetime. The number one threat to your assets during your lifetime for most people typically is long-term care costs. I mentioned earlier that Medicaid is the federal program, federal and state government benefits program that covers long-term care costs. As many people understand, Medicaid is what's called an impoverishment program. That's true, and it's not true. I'm going to give you a quick medical or Medicaid primer on some rules to give you context. Medicaid allows for a single person that they can have only $2,000 in countable assets. That pretty much is impoverishment. A single person, however, can have a car. Okay. They can also own their home, and the equity in their home can be $1,071,000. So that's not quite impoverishment. They can have $1 million plus house and qualify for the Medicaid program. So when it comes to a single person, there is a lot that an elder law attorney can do to protect that house so that it doesn't end up going to the state. We can help qualify the person for Medicaid, and through Medicaid asset preservation strategies, we can protect that house from the state's lien. So there are things that can be done. But if this person we're talking about that needs long-term care does not have a good, effective, durable power of attorney for finances, we might not be able to implement those Medicaid strategies that would protect the house. That's one of the reasons that you want to make sure that your estate planning documents are prepared by an attorney who has expertise in Medicaid. And typically that will be an elder law attorney, but not all elder law attorneys have that expertise. Ask the question. Ask your attorney, do you have Medicaid expertise? And if they don't, perhaps you want to find a lawyer who does. Let's talk about a couple. A couple in Medicaid is not an impoverishment program. The basic standard for a couple to qualify for Medicaid is in Washington State as of January of 2024 is that a couple can have between $70,000 and $156,000 in countable assets. Plus, they can have a car and all their personal possessions. Plus, they can have a house of unlimited value. It's not limited by the $1 million equity limit a single person has. So with a couple, they can have, a significant amount of assets. And beyond that, let's say this couple has $200,000 more than what's allowed in countable, $300,000 more than what's allowed in countable assets. Can we do a plan, a Medicaid asset preservation strategy for this couple to keep all their assets? The answer is yes, we can. Medicaid allows something called a Medicaid compliant annuity. And what that is that allows us to take the excess assets, put them in the name of the well spouse, that's the person who doesn't need care, turn those excess assets into non-countable by purchasing an annuity. And that allows us to qualify the ill spouse for Medicaid, and yet the well spouse gets to keep all of their assets. And beyond that, by transferring the name of the house, the title of the house, from both of their names only into the name of the well spouse, we completely avoid estate recovery of the state's lien on the house. So there is a lot that an elder law attorney can do to protect assets during your lifetime if you are a married couple and one of you requires expensive long-term care. But in order to implement these strategies, we need to have good estate planning documents. We need to have a good durable power of attorney with the necessary authority so that we could, for example, revoke a community property agreement, implement a separate property agreement, do any gifting that might be required. Though with a couple, it's rare that you need to do gifting. That's more for a single person. How can we do all of this? Well, we can't if we don't have a good durable power of attorney. That's why that is the most critical document you can have, not just to protect yourself and your voice, but your assets as well, so that all of your assets won't need to be spent down on the long-term care costs. Let's talk about trusts, because there's a lot of misunderstanding about trusts. And when you hear the term trust, that's like just the start of the conversation. Is it a revocable living trust? Is it an irrevocable trust? Is it an inter vivos or a lifetime trust? Is it a testamentary or a trust that is created through a will on death? So just saying the term trust actually should raise more questions for you. So I am going to talk about how trusts can protect you during your lifetime and how trusts don't protect you during your lifetime. The majority of trusts, when you hear the term trusts, are what are called revocable living trusts. That is a standard estate planning tool. The reason it is a standard estate planning tool is that a revocable living trust is intended to take the place of a will and a probate, because a will is something that needs to go through probate on your death. Probate is a court proceeding. Probate ensures that the will is carried out as it should be, that the assets go where they're supposed to go, that it is done correctly, because the court is there in order to make sure that that occurs. So you have a personal representative or an executor appointed, they need to carry out their job, but if they don't do it like they're supposed to, then there's the venue for making sure that they do carry out their job or replacing them or whatever. So I said court, right? What does that mean? That means there's going to be legal costs. I mean, people try to do it-yourself probates, and that's fine. And some people might be able to do so, but typically you are going to need the services of an attorney to do a probate. And whenever you're hiring a lawyer, that means you're going to be paying the attorney, and that means you are going to be, there are going to be fees involved. And legal fees, of course, are going to be higher than, somebody who's a bookkeeper, for example. So a lot of people want to avoid probate. And I forgot to mention, in other states, not Washington, not Idaho, but in other states, the legal fees of a probate are going to be tied to what's the value of the estate. In Washington and Idaho, we don't do that. The legal fees are tied to how much work was it? How good was the estate plan set up? How easy is it to do this estate? Did the court not need to be involved at all? We just had a non-intervention probate. We just filed the will and the petition, and then the court isn't involved at all, which is how typically a probate will go. But in other states, they look at what's the value of the house, and then the probate fees are tied to that. So of course, in states where the fees are tied to the value of the estate, you're going to want to avoid a probate, but that is not Washington. So in those states, a revocable living trust is a commonly used estate planning tool to avoid probate. In Washington, it certainly can be used as well. One of the things that is important to understand if you have a revocable living trust and you're in Washington and you are a couple is that there are very powerful asset protection tools that don't come with having a revocable living trust, that only come with having a will. For a couple, for example, if the first spouse dies and they have the right kind of will with an asset protection supplemental needs trust, we can protect half the couple's assets from Medicaid from long-term care costs. You cannot do that with a revocable living trust. So there are very good reasons to have a probate. Not all estates need to protect assets in that manner. Sometimes a revocable living trust is appropriate, even in Washington, to avoid a probate. But what's important is you understand what your situation is. Don't just go with a revocable living trust because somebody said, oh, you avoid probate. Find out what the benefits of probate might be. Why might you want to go through probate, your will? Why might you not want to have a revocable living trust? I can tell you from the revocable living trusts that we see, oftentimes the problem with them is that they are not funded. If they're not funded, in other words, let's say the bank account isn't titled in the name of the trust, or the house is not titled in the name of the trust, the trustee of the trust, then there will be a probate, plus there'll be a revocable living trust administration. So with a revocable living trust, it's not a sign it and you're done. It's a sign the document, fund the trust, manage the trust for the rest of your life. You get new assets that are titled, they need to go in the trust. You buy a house, sell a house, it needs to be done through the trust. So keep in mind, if you have a revocable living trust, it's a document that has to be changed and managed as you go through your life. One of the things that people believe that a revocable living trust does, but it does not do, at least not in the state of Washington, is it does not protect assets for you at all. You get sued, your revocable living trust is a see-through entity, just like you owned it outright in your name. Having it in a revocable living trust does not in any way protect that asset from your loss of the asset if you get sued by a creditor. So don't fall for this mistaken notion that a revocable living trust, at least in Washington, protects assets for you. It does not, period. What kind of trust might protect assets for you that you create during your lifetime? An irrevocable trust can protect assets for you against creditors, against claims, but it must be irrevocable. Irrevocable means you gave that asset away. You no longer own it. This irrevocable trust has its own tax ID number. It doesn't use your Social Security number. And the whole idea with an irrevocable trust is you can't get that asset back. You gave it away. Irrevocable trust can be very useful for Medicaid planning, tax planning. You can't use it if you're trying to avoid creditors that you believe are going to be coming after you, because that's defrauding your creditor. So irrevocable trust can be a very useful planning tool to protect you and to protect your assets. You'll definitely want to talk with your attorney about it. You do not do an irrevocable trust on your own. Other ways what I just talked about, revocable living trust and irrevocable living trust, I was talking about them from the perspective of what you create while you're alive. Keep in mind that you can create trusts through your will after your death. And you can create trusts for your kids, for your grandkids, special needs kids, for your spouse. If you in your will have this supplemental needs trust for your spouse, on your death, what happens is the assets that are yours. Let's say you're in a community property jurisdiction like Washington, you own 50%, your spouse owns 50%. You have $1 million estate. You die first. Through your will, through the probate, your $500,000 share of the estate goes into this special trust for your spouse. That ensures that your spouse will never become impoverished, no matter what happens, even if they need expensive long-term care. Why is that? Because the assets that are in the supplemental needs trust are not counted by Medicaid. They do not interfere with eligibility. They are not subject to any creditors, to any taxes on death, inheritance, estate taxes, once they are in that trust when the beneficiary dies. Creditors can't get at them. So not only do you ensure that your spouse has that nest egg, but then let's say you have 2 kids and you wanted to make sure your kids get something, that $500,000, what's left of that is going to be divided between those 2 kids. So you ensure that assets go where you want them to go and they're protected. That is done through a will. And recall, a will that creates a trust, that trust is called a testamentary trust. So testamentary trusts are very powerful asset protection tools. How do you make sure that you have that for your spouse or other beneficiary who you want to make sure they have asset protection? During your lifetime, you do create a will that has those protections in it. Getting back to other ways to protect assets during your lifetime, not post-death. LLCs, they're limited liability companies. These are very useful planning tools. Let's say you own a rental property. You can put your rental property into a limited liability company. You register it with the state. You make sure that you do the annual renewals of the LLC. And by putting that rental property into an LLC, you have protected your other assets from lawsuits. So it's a rental property and it has an electrical issue and a fire is caused and maybe somebody is hurt, maybe somebody is killed. In that personal injury lawsuit, the plaintiff can go against the LLC asset. But if it's done correctly, the LLC, they should not be able to come against you for your own assets. So if you have a situation where you have rental property or other properties like that, do see an attorney and make sure that you understand how an LLC might protect you. One of the things, just from a common sense perspective, is one of the best ways to protect you and your assets is to have adequate liability insurance. If you have adequate liability insurance and you get sued, the insurance company is not only defending you, but they are paying any settlement or claim. So have adequate liability insurance to protect you. This isn't an estate planning document or tool. This is just coming from an estate planning attorney who spent the first 2 decades of her life doing insurance defense litigation. So make sure you have adequate, my life as a lawyer, I should say. My first 2 decades of my life as an attorney was as an insurance defense attorney. So have adequate insurance, have excess or an umbrella policy to pay in case it's a very big claim. That's one of the easiest and most effective ways that you can protect your assets during your lifetime. All right, so that is the key ways to protect you during your lifetime. Let me take a look and see if there's in the chat and questions and answers. So I'll answer those. Question about powers of attorney. Is there a difference between a durable power of attorney as opposed to just a power of attorney? Yes, a durable power of attorney is durable. It has to say that. It has to have that language. And a durable power of attorney remains in effect even when the person who signed that document, the principal, has lost capacity. If the document itself is not durable, if it doesn't say those words, then it will no longer have an effect, won't be in effect when that person loses capacity. So it should be durable. Keep in mind that people often use the term POA not to refer to the document itself, but to refer to the person who is acting under the document. The POA is sometimes used to refer to the agent, to the attorney in fact. So when you're using the language about a POA, are you talking about the person acting under the durable power of attorney document, or are you talking about the document itself is a power of attorney? You want to have a durable power of attorney document, and the person acting under it is often called the POA, the agent, or the attorney in fact. Next question. My parent quitclaimed her house. All she has is cash on hand, $150,000, that she would like to pass on to her children rather than pay should she end up in a nursing home. That's $15,000 a year allowed by the IRS. What are her options? That is not a question that I can answer right now, but what I can tell you is I believe the IRS. So when we're talking about Medicaid and gifting and the IRS and what gifting they allow, they don't compute. They are not the same set of rules. So the $15,000 that the IRS is called the annual exclusion gifting amount. I believe it's $18,000 this year. It used to be 10 years ago. Continually goes up. I believe it's $18,000 in 2024. So what that means is the IRS says you can give away $18,000 to anybody. Actually, let's say your family is 10 people. You want to give away, or let's say 15 people, all your $150,000. You can do it in 1 year and not even mention to the IRS because you gave, well, the math doesn't work out, but you follow my point. You can give $18,000 to this person, $18,000 to that, $18,000, $18,000, $18,000. You don't even need to file a gift tax return. The IRS actually says you can give away this year $13.61 million without any gift tax imposed, but you do have to tell them about it because that is the federal exclusion amount this year. Medicaid has a much different set of rules. They have what's called a 5-year look back. And if you give away any assets within the 5-year look back, you're going to be looking at, is there a penalty associated with giving away that money? And generally the answer is yes, there is. So Medicaid's rules and giving away assets, you absolutely need to be talking to an elder law attorney about what's the best plan to make sure that there will be qualification for Medicaid and the assets are preserved. That is the expertise that we do have here at ELG Estate Planning. So if you're interested in exploring that more, just reach out to us. For single adults, is there a difference in what trust options we have? Again, it really all depends on your situation. Are you trying to avoid estate taxes? Do we need to get your level below Washington's $2.193 million? Or are we trying to protect money for Medicaid qualification? Because depending on what the situation is, there's going to be trust options available, and they will definitely be different. I wish I could give you definitive answers on questions on your particular situation, but I can't. I'm trying to share as much information as I can to help educate. And my goal with educating is to let you know that, yes, you can take action, but when it comes to complicated actions, Medicaid actions, irrevocable trusts, avoiding estate taxes, those sorts of things, reaching out to an attorney who's qualified in those areas is really going to be what's required. All right, I'm not seeing any other questions, so I'm going to go ahead and wrap it up. We have, if you're looking at the chat, we have like hundreds of videos on our YouTube channel. So if you look up Elder Law Group PLLC, That is, I believe, the name of our YouTube channel. You'll find a lot there. Of course, reach out to us here at Elder Law Group ELG Estate Planning. Our phone number is 509-468-0551, or go to our website, elderlawgroupwa.com or elgwa.com. We have lots of resources there. Thank you for spending your valuable time with me today. I truly appreciate it. I look forward to talking with you at some point. Thanks so much. Bye-bye.